Everybody say, ah. Say, oh, oh. Say, how can I express
my gratitude
for all the many things
you've done for me?
Words are not enough, yeah.
Enough to say thank you.
Say, Lord, you are my everything.
You're my everything.
How can I express my gratitude?
How can I express my gratitude
for all the many things,
you've
Father,
done
you
for
done
me?
for me, yeah.
Words are not enough to say thank you.
Say, Lord, you are,
Lord,
you
you're
are.
my everything.
Say, I call you Jireh.
You're my provider.
I call you Nisi. You are my battle. I call you Rapha. Hey.
You are my healer.
Say, Lord, you are.
You're my everything.
I call you Jireh.
You're my provider.
I call you Nisi. You are my banner. I call you Rapha.
You are my healer.
Say, Lord, you are. You are.
You're my everything.
Uya matinyana. Uya matinyana. Uya matinyana. Oh, uya matinyana. Yeah, so uya.
Moya matinina. Moya matinina.
Yeah.
Moya matinina.
Oh, uya matinyana. Say, I call you Jireh. Say,
You are here because you are very special to us. It's a wonderful good afternoon to you and welcome to the community and the law. This afternoon we're looking at 1, 2, 3 things you can do when your UK visa application is refused. If you're ready for that, let's get into it as we start and journey on the program, The Community and the Law, brought to you by BWF Solicitors.
Hello. Yeah, you're good. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on all the issues, immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn. At BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345, or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Good afternoon once again, and a very warm welcome to you to the program, The Community and the Law, this very wonderful Saturday afternoon here in the UK, and of course, streaming on social media to all of you around the world. My name is Riku Frimpon, and I have the honor and the privilege to be hosting this event between now and 6 o'clock. That's for the next 2 hours. Welcome on board, first of all. Thank you for doing that. And I would want you to do me a big favor. Announce yourself on the platform, either on Facebook or YouTube, at BWF Solicitors and at BWTV. The journey today is going to help us to know which 3 actions we can take when our UK visa application is refused. What type of application are we looking at? How do we go about those actions? And of course, what results are we expecting to have when we take those 3 actions? And this afternoon, I have the honor and the privilege again to have Lawyer Charles Asma from the stables of BWF Solicitors to help us go through that. So, call a friend, for the friend to call a friend, and to announce to the whole world that we are here with that body of knowledge to help you in this encounter. So definitely, if you are on and you've done that, thank you very much. Appreciate you, and I'll be acknowledging you by name later on. We have certain things we need to go through quickly to do as part of our house cleaning. And first of all, we want to show the appreciation people have shown to BWF Solicitors. And one is coming from Laurentia. Laurentia says that she's thrilled to share her experience with BWF Solicitors regarding her daughter's skilled worker dependent visa application. According to Laurentia, the team was very professional, supportive, and guided them through the entire process seamlessly. They were kept informed at every step of the way, and the expertise truly made a difference. Now, Laurentia says, I highly recommend their services to everyone in need of immigration assistance. Thank you very much, Laurentia. Yes, you are also very much appreciated. BWF Solicitors is grateful that you had trust in them and you gave them your business to handle on your behalf. Once you have had success, I know the rest will be cool, so easy and um, very smooth sailing. And others who would want to experience that, call BWF Solicitors on 0208 493 7340. I say the number again, 0208 493 7340. In Ghana, you can call their number on 055 589 5959. 055 589 5959. In emergency situations, wherever you are in the world, 0044 77 127 61884. 0044 77 127 61884. You can find the numbers on the screen as I read them out. So thank you very much, Laurentia. We appreciate you, and we know you will bring us continued business and recommend us to other people as well as you are doing in your review. You can also review whatever experience you have with BWF Solicitors, provide us feedback, and work on that for the benefit of the two sides, both BWF Solicitors on the professional side and you on the client side as well. Okay, BWF Solicitors, thank you. As we go through that, the updates keep coming and you keep dropping them to us. And this afternoon, we have one to share with the community. We're looking at health and care visa applications. Now, the Home Office is released its latest monthly monitoring report on entry clearance visa applications for the month of February 2025. And they highlighted key strengths in work, study, and family visa applications. The health and care worker visa category saw a major decline. Applications peaked at 18,300 in August 2023, but have now dropped to just about 1,700 in February 2025 due to stricter employer compliance measures and new policy restrictions introduced in spring 2024. So, August, September, October, November, December, January, February, 7 months down the line, there's been a huge drop in applications from 18,300 to 1,700 in February 2025. That's one update we can give you. There's more to come your way. Let's look at the next one we have. The adult care sponsors situation has an update. And what the Home Office is saying that adult care sponsors can no longer recruit from overseas unless they show an attempt to recruit from those already in the UK. Now, it's saying that from the 9th of February, which is a few weeks away, care providers who want to recruit a new worker from overseas must first prove that they have attempted to recruit a worker from within England who needs new sponsorship. Stephen Kernock, Minister of State for Care, said, as we crack down on shameful rogue operators exploiting overseas workers here in the UK, we must do all we can to get the victims back into rewarding careers in adult social care. I took the statement from the Statement on Change in Immigration Rules, HC 733, which is dated on the 12th of March 2025. And thank you, BWF Solicitors, for allowing us to give this to the community. So take note of that for me. Now, some knowledge. Do you know that if your partner experiences a miscarriage, both of you are entitled to paid leave? Did you know that if your partner experiences a miscarriage, both of you are entitled to paid leave? Well, I know some details would come your way from our brother and senior colleague from BWF Solicitors, Lawyer Charles Osman. But let me read what the new Employment Right Bill for 2024 says. The UK government has confirmed that parents who experience a miscarriage before 24 weeks of pregnancy will now be entitled to statutory bereavement leave of 2 weeks. Under the existing law, statutory bereavement leave applies only in cases of stillbirth, which is deemed to occur after 24 weeks of pregnancy or the death of a child. The new measure, which applies in England, Wales, and Scotland, ensures that both mothers and their parents can take up to 2 weeks of bereavement leave following miscarriage, regardless of the state of the pregnancy. So, pregnancy and maternity is a protected characteristic under the Equality Act of 2010. And as I said, this is from the new Employment Right Bill of 2024. For further details, I'll be giving you later on and next on the program, but you can call BWF Solicitors on 0208-493-7340 and they can help you with some explanation. You may want further light thrown on this one, so speak to BWF Solicitors. They're on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters in North London. Call them, as I say, 0208-493-7340. They work from Monday to Friday between 9:30 in the morning and 6 p.m. Now, when you come by train, you use the Victoria line, get off at Seven Sisters train station, use exit number 2, that will bring you to the frontage of the Anna House. Now, enter the building, go to the 4th floor, that's where BWF Solicitors are. So don't forget the number again, 0208-493-7340. That's the number of BWF Solicitors. Now, with that, let's see what explanation we can have, what clarification you can get on this one. And with that, I want to introduce my guest and resource person from the stables of BWF Solicitors, Lawyer Charles Asma. Uncle Charles, good afternoon.
Good afternoon, Rakuku.
How are you doing, boss?
Very well. How are you?
I'm good. The sun is out so well. We're happy. I could see people wearing t-shirts and shorts. I'm like, yeah, you all were praying for the sun to come out. Well, that's a nice sign. So we're good.
Great.
Yeah.
Right. Yes.
Well, I think on behalf of viewers, listeners, and clients, I want to thank you and welcome you to the show. And as part of the welcome, I want to throw this to you to help us look at that. We're talking about couples, the lady being pregnant, now having the unfortunate situation of miscarriage, 24 weeks of pregnancy. And the law says, or the new directive or the bill, the rights situation says that both parents of the child who unfortunately may have passed on are entitled to 2 weeks of bereavement leave. What was the situation before then, and what has brought up this new update?
Thank you very much. So there are three things here to look at. First is couple
Mm-hmm.
who are working either at the same place or different place and have had a child. The default position is that
Mm-hmm.
you get paternity and maternity leave for either of you.
Okay.
That is when the child is born.
Okay.
What about the child is born but couldn't survive, or the child couldn't actually enter the world in the first place?
Okay.
Do they get maternity or paternity leave? In the context of the word, the answer will be no. Because if you are not a nursing mother or quote unquote a nursing father, you cannot go on maternity or paternity because there's no child to care for.
Okay.
Now, does that punish those who are already grieving for the loss of the child because the child is stillbirth or the child died upon arrival? It appears so. And so the position then was that if you are not getting maternity or paternity because you couldn't have your baby, either to be born or was born but not alive, then you get bereavement leave
Mhm.
And such bereavement leave will accrue to both mother and father. And that will be for 2 weeks. However, there is a caveat.
Mhm.
The caveat is that the child should have been alive up to the 6th month, which is 24 weeks.
Okay.
And we are looking at default position within human gestation period of 36 weeks. And so if 36 is 9 months, then 24 will
Will be
be
6.
6 months.
All right.
So after 24 weeks of pregnancy, we deem the baby to be human or the unborn child to be human. And if the unborn child is born dead, which is stillbirth, then you have bereavement holiday as a mother or father to go through that bereavement or grief.
So it presupposes that if the fetus is less than 24 weeks, then you will not qualify for that 2 week bereavement leave.
Within the biological context and scientific classification of human and not yet human, 24 weeks was the standard. And so this was the case.
Mm.
There has been a conversation about this, whether it is fair or not fair,
Of this
because there are
program.
instances where children are born premature
Mhm.
and they go through the incubation process to be able to live. And so, if you say that the child was born before or was not able to survive up to 6 months or 24 weeks, what about a child who was born premature in 5 months or 5.5 months or a day before 24 months and was able to survive? And you are going to give the mother or father maternity or paternity, then is that different from me who has suffered the loss of the child 5.5 weeks, 5.5 months?
Mhm.
I don't know if you get the analysis.
Yeah.
And it appears to be some level of disparity. And so this has seen parliamentary consideration, and a bill, the 2024 bill, has gone through consideration, and it appears that it is now possible that if the child is not able to be born, or the child is stillbirth, or born dead, or is not able to survive, regardless of how long, the child parents will be able to have time to go through the bereavement process with a view to heal and to recover. And so the new measure, which will apply in England and Wales, of course, here there's bit extension up to Scotland, will ensure that regardless of time, the parents will have opportunity to go through bereavement for 2 weeks.
The parents will have the opportunity to go through bereavement for 2 weeks, and that's the update to the new Employment Rights Bill 2024. Okay, so if you have had explanation to this, let me give you the scenario and ask you to consider it and see if you can give me some good answers at the end of the program. Um, uh, we're going to test your knowledge. This is not the one. Um, I think the first part of the question will come later on. I'll bring it later on as we move on. But at this time, we want to say thank you to those of you who have joined us on either Facebook or YouTube. And let me acknowledge you. We are going to discuss 3 actions you can take when your visa or UK visa application is refused. Nana Hima Sapong, hello Abusia for to wait, hello family. Thank you very much. We have Adeta Ibu. Good afternoon to every one of you out there with those emojis. Thank you. Tilly Duma, hello, lovely family. Thank you, Tilly. Wave back at you. Thank you very much for your time and your effort. Rebecca Amwako, good afternoon to you. Everyone, good afternoon to you as well, Reki. The next one we have Tilly Duma calling on people to join, calling Najimai particularly to come join us. Yes, Najimai, we're here waiting for you. Another edition of the Community and the Law is live and is on Facebook and YouTube at BWF Solicitors and at BWTV. Can I pay council tax while my wife too is paying council tax on a different house? Anchor Julius Chunesi is asking that question. We'll bring it up later on in the program and ask Lawyer to help us to answer that. Sandra Fraser, thank you very much. Good afternoon. You're asking all to share when they join. Yes, that's exactly what we want you to do. And that good favor will be returned with a thank you. Good evening, Nana. Rama Sewa, good evening to you as well. Thank you very much. Tilly, kindly share, comment, and like. Thank you with the love emoji. Thank you very much, Tilly. You keep doing that, and we so appreciate you. So with that, let's take one quick break, and when we come back, we'll delve into the discussion straight away. 3 actions. 1, 2, 3. Don't go away.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for heeding not to go away. If you stayed up to this time, then it means that you will love the rest. So I would encourage you to continue to stay with us. Like the page, share, and also invite people to come join as we share knowledge and also learn from the stables of BWF Solicitors. 3 actions you can take when your visa application to the UK is refused. Why would it be refused? And when it's refused, what do you do? Lawyer Charles Asma, as I've mentioned, is a lawyer from BWF Solicitors, and he has offered to help us go through this afternoon. Lawyer Asma, UK visa application, yes, you put in the application, the expectation is that it will succeed and you can travel to the UK or enter the UK for whatever reason that you applied the visa. So if it's refused, you're telling us that we can take second actions. 3 of them we are looking at, or there are 3 definite actions we have to take. Are there 3 of the many, or definite 3 that we have to take. The ball is now in your court. Take us through that. Maybe we'll look at what the reasons may be for the refusal of the visas and what the 3 actions we need to take. So, ladies and gentlemen, get ready. We get entering the classroom with our resource person, our lecturer, and our man of the moment, Lawyer Charles Asma.
Thank you very much, Brakoku. Viewers and listeners, once again, welcome to today's conversation. The conversation looks at 3 remedial actions.
Mhm.
And the remedial actions are such that they offer you opportunity to do something.
Yeah.
You don't have to, but if you choose to do something, these are the 3 actions you can take. You can't take all 3 at the same time. So you may choose one that applies to your circumstance. So we are looking at refusal of visa application. What should you do? It doesn't really matter the type of visa application. What we are looking at is that you applied and you have been refused for whatever reason.
Okay.
And if you are not happy, you seek remedy. If you are happy, then you try another application again another time. So we are looking at those who have been refused and are not happy. And so they are seeking redress. Obviously, nobody will be refused and feel happy.
Mhm.
And so this may be for everybody who would want to consider taking action based on time, cost, and other factors that may ought to be considered or have to be considered. Types of visas.
Mhm.
We have visitors visas for the UK. We have student visas for the UK. We have work visas for the UK. We have family visas for the UK. All these are visas.
Okay.
We also have things that borders on the immigration front, especially nationality aspect, where somebody may be applying to enter the UK on the basis of their right of abode or right to reside in the UK. So in this case, they are seeking right to re-enter or enter. That's a right of abode.
Mhm.
Somebody will say that it's still visa, but because those people are in by default people with residence or people with status, permanent status in the UK, they will seek right of abode to enter or to re-enter. Some will seek to get passport to enter the UK because they are already citizens. All these border on immigration. But for the conversation for today, we are looking at visa to enter the UK for temporary residence or for permanent residence. So we've touched on all of them. We are saying that once you have been refused a visa, you either do one of these 3 things. 1, you seek the person who made the decision to reconsider the decision within the rules.
Okay.
This is called administrative review. So that is one category of action that you can take. Administrative review.
So
Administrative review
in this
because
case, sorry for interrupting, but in this case, you are asking the person who made the decision to look at it again because you don't agree.
yes.
Okay.
So and it's called administrative review because the person who administered the assessment of the application concluded to refuse, and you think that they erred in doing so.
Mhm.
And if you think that they made a mistake in doing so, you seek them to review their own action or decision.
Okay.
And that is called administrative
Administrative
review.
review. Okay.
So administrative review simply means back to sender for it to be reconsidered.
Okay.
So that is my interpretation. So this is not textbook phrase. It's my interpretation. So back to sender. For the decision to be reconsidered, we call it administrative review. The sender is the caseworker who made the decision to refuse. So if you take it back to them with your reasons and evidence which have not been properly considered, then you are requesting them to review their own decision and to come back with a better decision.
Okay. What would be
Now,
the
administrative.
second point to do or second action to take, really?
All right. So possibly what I will do is that I will touch on all the three. Then after that, when there is time, we delve into each one in detail.
That'll be fine. Yeah.
So administrative review will be given to you. It's a remedy that you may be offered. So the caseworker will tell you that if you think you disagree with me, seek administrative review. And here you do it within the policy guidance appendix administrative review. Now, let's remember that administrative review is within public law or constitutional law because a decision to refuse made by a public officer, in other words, a government, which is inconsistent with a policy, a guidance, a convention, or a law, would need to be reviewed because it will be inconsistent with public law. So, insofar as the action is by a public officer, or public worker, in other words, the caseworker representing the embassy of United Kingdom elsewhere, or representing the Home Office in the UK, then the decision is by a public officer. So it borders on public law. Now, for that to happen, you have to show that there is unfairness in the decision, there is illegality in the decision, or that the decision itself is not reasonable, is harsh, and inconsistent with common sense. So these are the three grounds you can rely on, one of which, or all of them, to seek administrative review. We move on to the second category of action. It's called appeal. You appeal when you think the caseworker did not follow law or the rules to make the decision. In this case, again, they will ask you if you wish to appeal to appeal. This is not back to sender, but back to a referee.
Okay.
So you refer the matter to an independent adjudicator called the court or the immigration tribunal. And this will be brought under the lower level of court, immigration court, which is the first tier tribunal. And the policy to refer to is the first tier tribunal procedure rules 2014, which tells people who have been refused UK visa and they have right to appeal what they have to do to assert their right or to seek remedy. So we have looked at two remedies. One, administrative review is a remedy because you want to be listened to.
Okay.
Or appeal. In this case, you go to a referee, which is the court. What if you are not told that you can appeal or you can seek administrative review? If the caseworker hasn't told you anything, that means there's nothing, isn't it? Then you go for common sense action because there's nothing given to you. And you cannot also say that nothing is told or offered, so I won't do anything. So you go for the last one, which is judicial review.
And that's also to another referee, isn't it?
That is to a referee. And in this case, the referee will not be. So when we talk of referees, we are referring to the court for the purposes of understanding, so that viewers and listeners can follow the conversation. And I'm trying to break it down so that we can relate to the law.
Right.
So the first one, back to the sender of the decision, that is Home Office or the caseworker, administrative review. The second one, to the referee, appeal at the lower level of the immigration tribunal process or structure, which is the first tier tribunal. But where you are not told or offered one of these two remedies, admin review or appeal, then you can go to a senior referee
Okay.
with FIFA ranking. And the senior referee with FIFA ranking is called upper tribunal
Right.
within the structure of the immigration court or adjudication. So the upper tribunal will hear your concern. And your concern will be that I'm coming to you to give me permission to apply for judicial review, in that the decision is not fair, it's not procedurally correct, or it is perverse, unreasonable, or harsh.
Okay.
And because of that, I want you, senior referee, to look at it and tell me whether I am wrong or the person who made the decision is wrong.
Right. So we're looking at three actions, and you have outlined them. First, you go back to the person that made the decision and tell the person you are wrong. So look at it again, review it. The person may ask you that if you do not agree with me, go to court. So is you are given the right of appeal, then you do that. But if in those two situations nothing is set to you, then you go to a senior referee, which is the upper tribunal, to say that this decision has been made against me and I do not agree. So please let or compel them to look at it and correct the mistake that I say they have made. Would that be what it is that we're looking at?
Okay, yeah. So to an extent, but I just want to buttress it that it is not the case that they will say do A and go to B and go to C. No, it is
Okay.
not and, it is all.
Okay. So
You
you can do
either
administrative review, or go for an appeal, or you can decide to go to the upper tribunal for an adjudication.
for judicial review, provided, and each one has some conditions.
Okay.
So once the decision is made by the decision maker must, within the rules, give you remedy to explore.
Okay.
So if they give you a particular remedy, that is what you pursue.
Okay.
So, for example, student visa applications or skilled worker applications,
Mhm.
they will tell you that it's been refused. You have 14 days or 28 days to go for administrative review.
Okay.
That's the next steps within the decision letter.
Mhm.
So you have to identify, one, what have I been asked to do? So if you have been asked to do A, you have to pursue A.
Okay.
If you haven't been asked to do anything at all, that means you have not been given any choice or remedy. An example of an instance where you have nothing to be offered is visitor's visa application refusal.
Okay.
So with visitor's visa application refusal, you don't have any remedy because it's not by force that you should be allowed into the UK to visit. So the caseworker will not give you any chance to pursue a right.
Okay.
But because it's a decision by a public officer, it falls within the purview of constitutionality or public law.
Mhm.
And because it's public law matter, refusing my visa application decision to visit the UK, I have to seek judicial review of that matter because there will be no admin review for me to go back to the sender, and there will be no appeal for me to go to the referee for. And so I have to go to the super referee or upper tribunal, which looks at such decision without remedy.
The obvious question somebody will ask is this: when a decision is made against you, do they necessarily have to give you an option of remedy?
Well, every action has procedure that ought to be followed or has some guidance.
Okay.
And so, if you tell me, for example, that if I have been offered admission to enter the UK to further my education,
Mhm.
and I have complied with that admission process, and I'm seeking entry to enter the UK, and for reasons untenable, you refuse me the visa, then you are preventing me, aren't you?
Obviously, yeah.
Who pays for all the costs that I might have incurred in the admission process?
Well, it becomes a burden on you, so you want to seek remedy so that it could be refunded or something, or you get the benefit of the amount you have paid.
So you see that when it comes to student visas, it's a checklist thing. Tick, 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 tick. They have to give you the visa. If they don't give you the visa, then they have to tell you why they didn't give you the visa. If those reasons are not reasonable or the reasons did not follow procedure, then you can seek them to review the decision. And so they must give you administrative review remedy.
Okay.
So what are we saying? All decisions, all visa applications that requires tick box exercise,
Mhm.
less discretion, more of checklist. Then the person, if they meet the checklist within the rules, must be granted.
Okay.
If they are not granted, then they must be told why. If the reasons are not tenable, then you can seek a review of those decisions or that decision. Either you go to court by if I'm told to go to court, or I seek admin review if I
Agree.
don't have right to go to court. The other ones will be the ones that are heavily discretionary, and that is visitors visa application, for example, and some other ones. That the caseworker has discretion to say, I will grant you permission to enter the UK for whatever reason or not. And they will usually, if they want to refuse you, have a reason to say, either because of your money, either because of this, either because of that, we won't give it to you. Because there's no checklist per se.
Okay.
And so with that, they will tell you that on this occasion, we are not satisfied that you have XYZ, and so we are not satisfied that if you enter the UK, you are likely to return. Sometimes they won't say you are likely to return. They say we are not satisfied that you are a genuine visitor to the UK. That's discretion, isn't it?
Yeah. The
And
person is thinking that that's what it is, not by
yeah,
definition.
or maybe he feels that, well, because the criteria is very wide, they will look at which part on the continuum of discretion to exercise,
Mhm.
either to favor you or to favor the government. And if that discretion is exercised without opportunity for remedy, you go for judicial review because, in your view, it is not fair, it is not reasonable, or it is procedurally incorrect.
We live on the community and the law, brought to you by BWF Solicitors, our trusted partners when it comes to the law. This afternoon, we're looking at 3 actions anyone can take when their UK visa application is refused. Laura has given us those 3 situations and told us in very plain and simple language to the layman, saying that the first one is return to the sender, the person who made that decision. Second one, seek the support of a referee or send it to a referee to make that decision for you, or to ask them to review the decision or change it in your favor. And then if you are not giving those 2 options, either an admin review or an appeal, common sense tells you that you go to hire referee and ask them to get the person who made the decision to review the decision and change it to your favor if that is what it is, and you may have to adduce reasons and all that. I know you've got questions, and I know you've got some concerns probably on other topics, but particularly this one. If you have anything you would want to ask lawyer, you can put that in the comment section down below, either on Facebook or YouTube, or you can send it to our text number 07399 208 and that's for WhatsApp as well. 07399 208 You can do a voice note if you are confident enough to do that for us to present to Lawyer Charles Asma to help you with an answer. And then again, when the lines are active, you can call on 0208 493 7345. 0208 493 7345. We'll be coming to look at this again briefly, but I would want us to get ourselves in the relaxing seat, think about our questions, and then we'll give you this message. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Thank you very much for sticking around. We're live on BWF Solicitors Facebook page and YouTube page, and on BWTV Facebook and YouTube pages as well. 3 actions you can take when your UK visa application is refused, and we're coming your way courtesy BWF Solicitors. And this afternoon, our resource person and guest is Lawyer Charles Asma. We call him the UK Solicitor, the Line of Hope. If you want to catch him and speak to him directly, you can call on 07947 636037. 07947 636037. Before I go back to Lawyer Asma, we were talking about the bereavement leave that parents can enjoy when, after 24 weeks, the lady suffers miscarriage. The UK government has confirmed that parents who experience miscarriage before 24 weeks of pregnancy will now be entitled to statutory bereavement leave of 2 weeks. Under the existing law, statutory bereavement leave applies only in cases of stillbirth, which is deemed to occur after 24 weeks of pregnancy, or the death of a child. The new measure, which applies in England, Wales, and Scotland, ensures that both mothers and their partners can take up to 2 weeks of bereavement leave following miscarriage, regardless of the state of pregnancy. Pregnancy and maternity, remember, is a protected characteristic under the Equality Act of 2010. So we'll be looking at Ajo, who got pregnant and had miscarriage before 20, in fact, around 23 weeks. Her partner, Kabute, wanted to take paid leave from work to support her at home while they grieve the loss of their daughter. The question I'm asking is, can Kabute take paid leave to support his partner, Ajo? Three options. Yes, he's entitled to 2 weeks of paid leave as a partner of Ajo. No, because the pregnancy was less than 24 weeks. Remember, I said the miscarriage happened 23 weeks. And yes, because the law provides for paternity leave. Think about that. We'll be coming back to that. Our resource person, lawyer Charles Osman, has graciously explained what the situation is. And I am asking you that question. So when we come back, we'll ask that. But three actions you can take when your UK visa application is refused: administrative review, appeal, and judicial review. Lasma, who does these three actions on different situations or in different situations and occasions? Is it the person who has made the application, or it has to be a lawyer who has to do all these three things for whoever is in that situation?
Thank you very much. So, first off, it is not the lawyer's refusal.
Mhm.
So, it is the individual to pursue. But lawyers are there for such unfair treatments.
Mhm.
And so the individual can seek the representation of a lawyer so that the lawyer will use the law to support their cause. Because administrative review, for example, you have to come up with your grounds or reasons
Mhm.
that prove that there has been unfairness or there has been misapplication of the rules or the law in making that decision.
Okay.
And so, if you don't have grounds or reasons for challenging the decision by way of going back to the sender, which is the administrative review, then on what basis are you not happy?
All right.
And because it is law, it gets technical. So, if you are asking if it is advisable for listeners and viewers to seek the representation of a lawyer, I would say it is very good to do so.
And for that, I would want to repeat the kind of advice I give all the time, that it is always advisable for a layman to give his work for an artisan to do for them. So I would recommend that you speak to BWF solicitors who are always ready and willing to help you go through these steps. You know, they're giving you the options, they're telling you what to do, they're telling you how to do it and the rest of it. So call them on 0208 493 7340 0208 493 7340. If you're outside of the UK, especially in Ghana, you can call them on 055 589 5959 055 589 5959, or the emergency number 077 127 884 077 127 61884. I've said that if you want to speak to Lawyer Asma himself and directly, you can call him on 07947 636037. Now, you just mentioned that for administrative review, for instance, you need to state your grounds. Um, is there any way you can help us know how to go about stating the grounds? Is it based on what reason they gave to refuse you, or you can adduce a certain new reasons why they should give you the or they should grant the visa for you?
Thank you very much. I think in one of our discussions previously, we looked at getting administrative review successful or done successfully.
Mhm.
And we showed example of the decision, the application review grounds we put together for the client, and the outcome for that client. And so, in terms of the argument, it's always you looking at what the caseworker has said that you disagree with,
Okay.
in terms that it doesn't follow logic or it doesn't follow the rules. For example, somebody will say that I am applying for post-study leave. And post-study leave, remember, is student aspect. I applied for it and I have been granted, I've been refused.
Mhm.
I want to challenge because I've been told that I can challenge by administrative review. So the first thing I want to ask this person is, one, did you qualify to make the application in the first place?
Okay.
Because for postgraduate, under appendix postgraduate leave, it tells you that once you have completed the course, you receive notice of completion from the university. The university will have to notify the home office that course has successfully been completed. Remember, they send your attendance to the home office. So if you have completed, they have to let them know that you have completed.
Mhm.
Home office will also write to you to say that your university has told us that you have successfully completed the course. Now, this is what is open to you. You can now apply to remain under the post-study provisions. So when you apply and they refuse you, then I will challenge them to say, hang on, the rules say that if person has completed the course, the university might notify you. If the university notifies you and the person applies, this is open to everybody. So on what basis did you refuse?
Reviews me, yeah.
I'll challenge on that basis because it's clear. And you can see that either the person didn't follow the rules or they forgot that the rule apply to this individual.
Mhm.
And either way, it will be either illegal, unreasonable, or procedurally incorrect. So, but this client comes to you to say that I have completed the course. I owe fees. And so my university has not taken me to the graduation process. I haven't received my certificate yet.
Mhm.
Home office hasn't come back to me with any letter or any email that the university has confirmed completion. I applied and I was refused. Is home office right to refuse? Here, let's yes or no. Home office refused. But the person says that the university did not confirm and home office was not also told, but they applied for postgraduate visa and they were refused. Will home office be right to refuse the person?
Um, I would say yes, because the Home Office hasn't really had any confirmation that you have completed one and you move into another. So it could be that you have not even completed your course of study.
So, looking at this, and this is the fact, the instruction from the client, for example, or the person is that I didn't have what it takes to make the application, but they went ahead to make the application anyway.
Mhm.
And you want to follow them to fight for them.
Mhm.
On what grounds are you going to fight?
Well,
And so that means, so what we are saying is that what you were asking about, how do you deduce what goes into the grounds?
that's right.
You do that on the basis that the client has been shortchanged or the person has been shortchanged. But if the person was trying to shortchange themselves, then will it be fair to follow them to fight,
You shall change yourself. Why am I following you?
so to speak? And so that is how you go through arguing your client case.
Okay.
Because your aim is to make sure that you win for your client. You are not winning, you are not following simply because you have to follow. You are following on the basis that one of the three reasons is present. One, the caseworker's decision that did not follow the rules or the procedure. But here we can say that the caseworker followed procedure because he didn't complete the course. Or even if you have finished your exams, you have not concluded the
Yeah.
process.
And you haven't even shown evidence that you have concluded. The institution hasn't confirmed that you have concluded. So if the caseworker is not sure, they will say, well, you haven't concluded.
Right. And so in this case, I will tell the client that, okay, if it's possible that you gave them everything, that is, if their story is otherwise, that they completed, they had everything, and blah, 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 they have evidence to suggest, then I will tell the caseworker that, yes, my client has everything, blah, 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 everything is here. You didn't consider the evidence you had. You misconstrued the evidence to be something else. But this is the application made. And so it appears that your assessment was in error. And so reconsider. So you put them on the spot within the rules. You point it out to them. Because they are human beings. Sometimes they forget their own rules. So you point it out to them. And they sit back and say, okay, in this case, you are right. But if you point it out to them and you are wrong, then they will come back and tell you that you didn't do it well. We did it right. Actually, the person did not provide evidence that they have completed. And that is why we refused. So before you go, make sure that you have clear evidence to support your claim. And it applies to any other administrative review process at all. But there's one that I will point out here. For example, visitor's visa, when it is refused. Recently, there's one client that we were pursuing a case for, visitor's visa for 5 family members. They were all refused, and we pursued judicial review because there's no remedy for them at the initial stage. So we pursued judicial review. But before you go for judicial review, you have to go to them to tell them that I'm not happy with the decision, and so fix it. And I think I came here some time ago during the conversations to say that there is one we are still pursuing, and the people have come back to say that they will come back with a response in the first week of January, if you can recall. That decision eventually came 2 weeks ago, and they have reversed their own refusal decision for visitors visa. And they've asked all of them to come for the visits because we raised a point that, yes, it didn't give them because of whatever you said, but these are people visiting their family in the UK. So you cannot punish them on that basis, thinking that this is what you feel. And they reversed the decision. So it didn't even get to judicial review. But that was the course because that was the remedy available.
Okay.
And so how did we do it? It is the case that we pursue the grounds or reasons or the argument on the basis that these are the issues present within the refusal. And this is what the rules say. And this is what we have to do to support the client case.
How many times can you go for administrative review for one particular case? Is it when you do it once and they come back to say, well, we can't rescind our decision, then that's the end of the story for that end, and probably then you may want to go and do judicial review. How many times can you appeal against administrative review?
Remember, administrative review is a remedy. Appeal is also a remedy.
Okay.
But judicial review, even though it's a remedy, is not given. So if somebody pursues administrative review and it is not successful, they can then explore the next level, which is judicial review, but not necessarily to go for appeal.
Okay. All right. Now, when you are given the right to appeal a decision, is it the same set of grounds that you may use for an administrative review, or because you're going to an arbiter, you would have to adduce certain legal reasons and arguments before you can do that in the case of an appeal?
Right. So appeal, judicial review, administrative review, you go with your reasons.
Okay.
Now, administrative review, tell them that this is what you said you will look for when you are considering such applications. Mine was one of such applications, and I gave you everything that you should be looking for, and you appear to have ignored some of them, and so fix it.
Okay.
When you are going to court, it's the same line of reasoning.
Okay.
telling the court that this is what the rules say. For example, you are applying to enter the UK to join your spouse under Appendix FM
Mhm.
partner. The rules are clear. If it is not about your character, which is suitability issue, then all four elements must be ticked. Money, you've ticked it, 29,000 from you or from your sponsor. English language, you've ticked it. Accommodation, you've ticked it. And relationship, you've ticked it.
Mhm.
So if I have ticked all the boxes the way you want it, and you don't give it to me, then is it my fault that I take the boxes right, or your fault that you didn't follow your own procedure?
Well, if they don't follow their own procedure, that's their fault because I have done what you asked me to do.
And so when I go to court, because I have the right of appeal, if my client is going through me, my argument will be that these are the conditions for this application. Client met all the conditions. Appears that there was poor assessment or erroneous assessment of the conditions, and
Mhm.
blah, 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 blah. We cite case law, we cite the rules, and we cite the statute where necessary to make a case that these are the reasons why we believe that the decision to refuse is unlawful.
Okay, right. Then I can presume that when we go in for judicial review, it would be the same reasons of not following the law, not following their own procedures, not following their own guidelines, and they may have shortchanged me.
Yes, there are similarities. The specific course of action will require specific level of argument or line of argument, but there are similarities.
How long does it take to get some of these wrong decisions reversed? Is there a length of time that I would have to wait for an admin review, appeal, or judicial review? I am thinking that probably for judicial review, it will take longer than the both of them earlier.
Yes, I will say what the rules say, and I also tell you what has been the case by
Okay.
experience.
Okay.
The rules say that if you apply for admin review, it should take about 28 days to get decision.
Right.
But does it always take 28 days? No. In recent times, it takes sometimes 1 year,
1 year.
sometimes 2 years, sometimes 6 months. In other
Wow.
words, it goes beyond the standard time. So it depends on what you are doing. If you have made the application for admin review, you've sent all the necessary things. So the first thing is you apply, you have 10 days, 10 working days within which to adduce your evidence together with your grounds or reasons. You sent it to the person or the sender who brought in other words, send it to the home office.
Mhm.
They will look into it. After 28 days, if they haven't, because the standard time says 28, you have the right to go back to them to say, I haven't heard from you. They write to you to say that we are looking at it, we haven't finished. You can go back to them again after some time to say, I still haven't heard from you. They will come back to say that, yes, we are aware, but we are still dealing with it. So it's a matter of your level of patience. So that is that. Once the decision comes, then they either maintain it or reverse the original decision. That means you are successful
Okay.
and so on. But if you are going for judicial review because you were not given one of the two actions or rights,
Mhm.
then there is time frame. In this case, again, administrative review, you have either 14 days or 28 days to put in your application. So I believe that you do it on time, because if you are late, it will go against you.
Okay.
Judicial review, you have 90 days to pursue a course of seeking redress. So you go to the sender to say that I intend to pursue judicial review against you because you did not give me any of the two initial options. So you send them what we call pre-action protocol letter, or you send them a notice of action.
Mhm.
Once you serve them the notice of action, we are looking at the time you receive the decision. Immediately, you have to send them the notice of action that I want to pursue judicial review against you because you didn't give me appeal or you didn't give me administrative review right. Then you start checking the time because you have 90 days to go to court with your judicial review application.
Mhm.
If you are late, senior referee, which is upper tribunal, will not entertain your claim because if you want equity, you must do it in time or get it in time. Delay defeats equity.
All right.
And so 90 days you come. But within the 90 days, you have to do the informal arrangement or informal resolution with them. That's why you send them the letter to say that I'm not happy with what you've said. Can you please look into it? Then they will come back. The moment you hear from them to say that you hear from us at a particular date, that will be the beginning of the substantive remedy that you are going to seek. So, for example, today you have been refused. Your 90 days for judicial review will start from today. However, you go to them with a letter that I intend to seek judicial review action. And after 1 month, they write you to say that, yes, please wait. You will hear from us in 2 months' time. Then the date you have been given, which is 2 months' time, becomes the date of the decision to be made. Are you with me?
Okay.
So if after 2 months' time, your 90 days, which is 3 months, is already gone, you make them the court aware that they gave you time, which is 2 months later, to wait. And therefore, it wasn't reasonable to go past the request to wait to go to court. And so by waiting for 2 more months and ending up doing more than 90 days, it is not my fault. It's because I was waiting. So then the court will understand that the actual decision that you are going to court for will be the current one, which has been decided after, let's say, 2 months, and not the original one that you sought them to look into for you. It may sound technical, but all that we are saying is that these things are all time bound. And so you have to make sure that you operate within the time. So you calculate the time so that you don't miss any step. How long will it take? Appeal, the rule is that it will last for about 48 weeks, which is almost 1 year. So once the decision is made, you have 14 days in country to put in your appeal, or 28 days out of country to put in your appeal. You have 28 days to send your home office has 28 days to bring their evidence. You have 42 days to send your evidence. You wait, then the court will make time for hearing. And so by the time everything is over, it will be about 48 weeks. It doesn't mean it has to be 48. Sometimes earlier than that, sometimes up to 48. After 48 weeks, we hear the matter in court. Once the hearing is over, you wait for about 6-8 weeks to get decision from court, and that will also increase the time. After decision is made, if you are successful, you wait for home office to implement the decision. Meanwhile, home office also has right to challenge that court decision, what we call onward appeal. And so you wait for them to challenge it. In country, 14 days, out of country, 28 days. And then the process will continue on and on. And so appeal can take longer than usual if it becomes largely contested. If it is not contested, then the winner will then expect action to be made about getting the visa. Or, of course, if my client loses or appeal is dismissed for my client, if the client is still wishing to, then per instruction will go to court, especially where we believe that there is reason to pursue it further to the next level, and on and on and on. Again, if you are late, you have to give reasons why you are late to bring the administrative review, or why you are late to bring appeal, or why you are late to bring the judicial review. If the court does not agree with you, or Home Office does not agree with you that your reasons are okay or understandable, then you are out. So there are a lot of technicalities and processes to follow. All we are saying is that you have 3 actions to pursue, open to you, and you have to do one of them at a time, not one after the other, one of them. So you choose one that applies to your case to pursue a remedy.
Well, it's all time bound, and the 3 options available, you'd have to choose one of them and pursue at a time. I would want to advise again that in taking any of these 3 actions, speak to a lawyer who knows what he or she is about. And I recommend BWF solicitors to you. Call them on 0208 493 7340. 077-127-61884. And if you want to speak to Lawyer Charles Asma directly, 07947 636037. 07947 636037. And on this program, if you would want to ask a question, either on the phone 0208 493 7345, or you can send a text message or voice note to our WhatsApp and text number 07399 208 468, 07399 208 468, or you can call in on 0208 493 7345. I'll be taking those comments you've put in the comment section down below on Facebook and YouTube, and we'll give them to Lawyer Charles Asma to do that. I'll pick the rest on our WhatsApp and text message numbers as well. So get ready. We will be right back to pick your questions and get the answers.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
So yes, the lines are active: 0208 493 7345. 07399208468 for text and WhatsApp messages, or on the social media platforms at BWF Solicitors, Facebook, YouTube, at BWTV, Facebook, YouTube. Lawyer Charles Asma is here, and this afternoon we have considered 3 actions you can take when your visa application to the UK has been refused. I know there are a couple of them on the platform, both on Facebook and YouTube. Let's start with those ones and ask lawyer Asma to help us. Can I pay tax, council tax, whilst my wife too is paying council tax on different houses? So yeah, I'm thinking that you kind of live in one place, but your partner or your wife has another property in her name and paying council tax on that one as well. Can both of you pay council tax at where you're living, and your wife will continue to pay council tax at the other property as well? Laura, can you help us, please? I think you're on mute, Laura.
Yes, we can help by shedding light on the law with respect to council tax rules or taxation process. One thing that is missing from the question, so if we go back to the question, there's something missing there.
Okay.
Bring the question back. It says, can I pay council tax whilst my wife is paying council tax on a different house? It didn't. The questioner didn't tell us whether they are living together or the wife is living at that place and he is living at this place. That is silent.
Okay.
So I'm going to make assumptions that wife is living there and he lives here.
Okay.
Or another assumption would be that they have two properties. They are all living at this place, and he has chosen to pay council tax here, and the wife pays council tax there. These are all permissible
scenarios
assumptions
we can look at.
Yeah, so please, if you can assist us with further bit, but let's go to the council tax rules. Producer, please. Who pays council tax? Brakoku, who pays council tax? Please help us.
So it says you usually have to pay council tax if you are 18 or over. A full council tax bill is based on at least 2 adults living in a home. Spouses and partners who live together are jointly responsible for paying the bill. Then it goes on to say who is not counted or who is disregarded. Some people are not counted or disregarded when working out how many people live in the property. This means you might be able to apply for a discount on your council tax bill if you get one. You are disregarded if you are under 18 years old, on certain apprentice schemes, 18 or 19 years old and in full-time education, a full-time student at college or university.
Yeah, Brakoku, let's answer the question by going through the checklist of disregards. So once we mention the first one, we'll see whether it applies to our client who is talking about himself and the partner on another property. So under 18, does it apply to them?
Well, the person didn't tell us, but once they are a couple, I'm assuming they are over 18.
Yeah, I mean, I also assume that this person will be over 18 because it says I and my wife, and we assume that somebody to have married and now living at their place and a wife controlling another property, they will be more than 18 years.
Yes. I think the person is giving us some further information. Yes, we are living together and address the same.
All right. So what about the other property for both of you, or your wife owns it? Who lives there?
So does it mean that let us if Mr. Chumesi, if you can help us, but we can assume at this point, once you haven't brought that piece of information, we can assume that probably before you got married, your wife was living in a different property, and probably now you are living together in that property. The wife has not given up that old property, so there's council tax liability over there, and there's council tax liability for both of you living in the same address at the moment. That's what I'm assuming and thinking, Laura.
Yes, so council tax is actually paid on property. Elsewhere, it is called property tax. In the UK, it's called council tax per se. So the council tax is supposed to raise revenue for the council or the borough to manage the community in which the property is situated. He says, I'm living there. Okay. Now, so what we are saying is that because the property is owned by somebody, the person, if they are not living in that property, will have to pay the council tax thereof.
Mhm.
I'm sure either the property is rented or it is about to be rented or they keep their things there. Either way, the property is in somebody else's name. And it's always the occupier's liability to pay the council tax. So if you're occupying it, you pay the council tax yourself. If a tenant is occupying it, the tenant will pay the council tax. And so if your wife has another property somewhere, what I would say is that check if it's rented. If it's rented, the tenant's name must be made known to the council for the tenant to pay the council tax. Otherwise, the owner will pay the council tax.
Okay. It kind of answers the question for our dear friend. So, Mr. Chimesiankra, if you have any further question, you can let us know. But Lloyd was taking us through the disregard criteria. Maybe we'll run through that quickly and get people to, or we can signpost people to the website for them to look at that. So you can be disregarded if you're under 18 years, you're on some certain apprentice schemes, you're 18 or 19 years old, but still in full time education. You're a full time student at a college or university. You are under 25 years old and you get funding from Education and Skills Funding Agency. You are a student nurse, you could be disregarded in the council tax. A foreign language assistant registered with the British Council. You are severely mentally impaired. You are a living carer for someone who is not your partner, spouse, or child under 18, or a diplomat. You can apply for a discount or exemption, but you need to apply for that even if you are disregarded. You get 50% of your bill if everyone living in your household is disregarded. You get 25% of your bill to pay council tax and in that situation, either you live on your own or everyone else in your home is disregarded. So remember, contact your local council if you're unsure about whether you can get a discount or who is responsible for paying. You can get all this from the .gov.uk website and you can put in council tax, how council tax works, and you get this link and this page, and you can go through all that. Thank you very much, Lawyer. I think we can appropriately move on to other questions at the moment. Let's see what Citizen Kweju says. Kofi was on a student visa, applied for an extension a month ago before his visa expired, and is still waiting for a decision. Lawyer, can Kofi make an application based on his marriage to his partner, who is currently on a 2.5 year visa based on her British child? Lawyer.
So the rules allow for, or the policy guidance allow for variation of pending application. So if Kofi's current application is not yet decided, Kofi can apply to vary the pending application.
Mhm.
The question Kofi will have to answer is, do you have a pending application? Kofi will say yes. What is the pending application reference number? Kofi will have to put in the reference number. Then Kofi will continue with the new application. And the new application will override the existing one, or the pending one will be varied by the one that Kofi will be making. So these are the rules regarding variation.
Okay. So yes, let's move on to other ones. You can send in yours on WhatsApp 0739920848. You can send it to the comment section on Facebook and YouTube, BWF Solicitors and BWTV. My naturalization application has been successful, and I want to apply for a British passport and filling out the form. There's a question which goes, have you ever used any other names? What exactly does it mean? Are they referring to names I previously used in making home office applications or names I officially changed on my documents? Why?
Both. Both. If, for example, if you have changed your name and your current passport bears a different name from, for example, your degree certificate, then you have to indicate that you have changed your name. Previously, you were known by this, and now this is your name, and this is the name you are using to make this application. Or previously, you have made the Home Office application to enter the UK or to extend your visa in the UK, and you are now going for naturalization. For somebody to be making a naturalization application, they would have at least made 3 applications. One, they entered the UK with, and maybe the other 2 they pursued whilst in the UK. An example could be that he pre-settled and settled before naturalization, or family 2.5 in, another 2.5 in, then naturalize. And even that, you go for indefinite as well before your naturalization. So either way, if your name is different from this current name is different from the ones you have used, you have to declare or disclose. So when they say, have you ever changed your name? You know yourself. So based on what you know, that the Home Office knows about you, about the name, please mention it. If it is not something that affects anything, I don't see why you wouldn't want to. So just whether officially or per previous applications, say yes and tell them what the new name is or the previous name was.
So if you don't and they find out that you quote unquote have lied, is that what we term as misrepresentation?
So the question is, oh, I'll come to that. But in coming to that, let me say this. The question is clear. Have you ever been known by another name? That is clear enough, isn't it?
Mhm.
And if you know that you've been known by another name and you say no and you move on, and it turns out that what they have about you is different from what you have told them, then they will conclude that you have misrepresented the responses.
Okay.
Then they will decide whatever they do with that about your conduct at this
Your
point.
conduct. Okay. All right. Well, let's keep it going. Let's see what other questions you would have. The lines, as I mentioned earlier, on are active 0208-493-7345. What could be the outcome of Kofi's application? Um, which application is that? Citizen
I
Kojo,
think
if you can
I think
clarify,
the
that would help.
variation, the
Oh,
variation.
okay. You're talking about the previous one. Can Kofi make an application based on his marriage to his partner who is currently on a 2.5 year visa based on her British child? And Kofi is asking what will be the outcome.
The outcome will be insofar as Kofi meet the rules. Either Kofi will be granted, Kofi will be refused with appeal right, or they will say the application requires further information to be provided. So either yes or no, they will tell Kofi, and Kofi will have to, if no, go to court to appeal. If yes, that's it.
Okay. Keep them coming through 0208-493-7345 is the number you can call. The text 07399-208468. Kwesi Sewusu says that I've got my 2.5 years on 2015 September. My last one is finishing 2027. Can I apply? I think that's what you mean. Can I apply for indefinite leave to remain in September?
I suppose in September 2025.
I'm assuming so. Or
Yeah.
is it September 2027?
Right. I mean, okay, so let's do the calculation.
Mhm.
2015 granted 2.5, the first 2.5, and I'm sure it's under the 10-year route. So 10 years from the 2.5, first 2.5 will be 2025, right?
Mhm.
September. But we know why Kofi's last leave will expire in 2027. Because from the second renewal up to the final renewal, Kofi's application delayed at the Home Office. Sometimes 6 months, sometimes 8 months, sometimes 1 year. And so when Kofi eventually got the last grant, the one he has will expire in 2027. However, Kofi will do the calculation and realize that I have been legally resident continuously for 10 years in the UK, even though my visa will be expiring in 2027. Do I qualify for indefinite and when? Kofi will qualify for indefinite in the month of the 10th anniversary from the first 2.5,
Okay.
which I calculated to be 2025 September. Even though the visa will expire, the last one will expire in 2027 because of delays here and there, we will look at whether the delay was because of Kojo's fault or delay at the Home Office based on their own operational issues.
Okay.
And so we look at the case of Afzal and the case of Iyeki. The case of Afzal and Iyeki say that if the delay was occasioned by Kofi, then Kofi will pay. Sorry, by what's the name of our friend? Is it Kofi? Okay. Okay. If the delay was occasioned by the person, then the punishment will have to be borne by the person by waiting to make up for the difference. In this case, the person cannot make an application now. And even that by 2027, we still have to check to see whether we can count towards the person's favor or can count in the favor of the Secretary of State. And so I want to believe that this person never had delay in making a renewal application. Anytime it was due, within 28 days, the person applied, and the delay was at the Home Office until it came. If that's the case, the person can apply for indefinite leave to remain on the 10th anniversary of the first grant of the 2.5.
Okay. Let's go on to the phone line 0208-493-7345. Hello.
Hello, good evening.
Good evening.
Well, it's unfortunately I can't hear.
Last man, you hear him. Don't worry. You shoot on.
Yeah, but I have two questions. Well, what are you doing?
Very well, thank you. How are you too?
No bad. Been a long time.
Okay. Last man, can you hear our friend?
Yes, I can hear our friend. Our friend, how are you?
How about is Mantubam on the
Oh, Antuba.
line?
Oh,
This is Antoba.
oh,
Yes.
Senior, how are you?
Yeah, I have some two questions. This is a question of clarification. The first one is concerning I've heard the last week. I think one of our guys who patronize on this platform as well was asking a question about if you go to Ghana with your British passport and when you are going, you went with your your British passport, and then when something happens while you are back in Ghana, I heard on the platform also that when something happens in Ghana, since you didn't go with your with a visa, when something happens to you, the United Kingdom is not going to treat you as a British citizen since you didn't obtain a visa to go to Ghana. Last week I heard him asking Uncle Ben as well, but the clarification was not very right because on another platform he said, yes, you're not. But Uncle Ben was saying, since you are a British citizen, why not? They have to care for you. So I want a clarification of that. If you are going and you don't obtain a visa and something happens to you in Ghana, are the British authorities not gonna give you any attention because you didn't obtain a visa? That's my number one question. And then number two, you want me to continue with the number two?
Hold on and let him address the first one first, right? Please.
The problem is because I can't hear actually from my end.
Can you hear me?
On the
Maybe
phone.
lower your set.
I can listen to you on the line, but I can't hear on my phone.
But obviously, you cannot hear me on both sides. So if you are using
So I'm
telephone,
gonna hang up. I'm gonna hang up and listen to you on air.
okay, all right.
Okay, so I'll come back with the second question.
Thank you so much. Okay, in this case, in order not for us to lose, in case you struggle to come back, ask the second question. Let me write it down.
Oh, I think it's got. Let me see if I can get him back on. Mr. Tubam, let's see if I can call you back.
Your call has been forwarded.
Oh. Sorry. Okay, Mr. Kenneth, if you can call back again and then you hold on, then we pick your second answer. Or the second question so you can answer. But let's attempt to answer the first one, lawyer.
Right. So, Antubam, I will take you to uh, the ladder of jurisprudence. I mean, the court structure.
Mhm.
So you see that we have lower courts and we have upper courts. And when a matter is decided by Supreme Court, for example, it becomes binding on the lower court. Decision by the lower court is only advisory to the upper court. And I'm happy to hear that you said that Uncle Ben, who is my mentor, senior partner of BWF Solicitors, and I see him to be the Supreme Court, has already proffered a view. And if the view is already proffered, I'll go by that. So we are not going to repeat that position. So Uncle has said that if you are British citizen and you are in danger in a foreign country, the embassy there should be able to assist you. And that is the position I will side. So please come with your second question and we proceed.
I was trying to call him back, but I think it's gone off. So let's pick other questions on there. If he comes back, I will get to look at that. The next one from the platform is yes, Nanechi, will a parent on a 10-year parent route be able to switch to 5-year route if all requirements are met? If yes, then on the 5-year route, can he or she apply for naturalization immediately after indefinite or 1 year or after or another 5 years after? Can we attempt an answer to that one?
Okay, all right. So I'm going to uh, put this into compartment because it's a longer stretch of a question. So the first part is, can you switch from 10 to 5 as a parent? So when you are living with your child and the child's mother, whether you are married or you are partners, insofar as you are living together as a family unit, the application will always be decided and granted under the 10-year route under Gen 3.2 provisions. So that is something we have to bear in mind. Now, the question is, can the person now switch to 5-year route? If you are still living with them as a family unit, it will still be decided under Gen 3.2. Now, what if you are now living alone? As a parent, you look after your child because you have sole responsibility. We have parental responsibility for your child, but the child lives with the other parent. Then you are switching. In this case, you are applying under direct access provisions. And so once you have met all the threshold under 5-year route, you will be granted under that. At this point, your journey will begin under 5-year route, and you have to do 5 years, 2.5, 2.5. So you disregard the first 2.5 under 10-year route and focus on the first and second 2.5 under the 5-year route. Your question is, how do I proceed to naturalization having done 5 years under 5-year route? Once you've done 5 years under 5-year route, you apply for indefinite leave to remain. After indefinite leave to remain, you apply for naturalization having held indefinite leave to remain for 1 year.
Okay, thank you. Let's go to the line again. I think our friend has come back. Kenneth, yes, let's hear you again.
Fine, then we will go with the Supreme Court.
We'll go with the Supreme Court.
So we will go with the second question was with this new bill that is coming concerning the illegal entrance to the UK. Let's say I came here with, I would say, deception, somebody's name, and then after entering, after I applied for stay and giving me limited stay, I did mention that I came here with somebody's name. So in a way, it's a deception anyway. So if it comes to the time to apply for the citizenship, if I put it on that I came with that name, but it wasn't mine, are they going to allow me to become a British citizen, or they going to refuse me because I didn't come to the country? Would I say legally, or because I did come here with somebody's name anyway, anyway? So I would like to know if that would be something that's going to affect my citizenship. Thank
Okay.
you.
All right. Thank you. Yeah. So we'll go the same way. Get you to listen online. So, lawyer, this is a situation where this person came in with a different name and identity. Along the line, the person has changed the name to the person's real identity and has been given permission to stay on. He has satisfied all the criteria. Now he wants to naturalize. When they put in the application and they say that they entered with a particular identity, now they have another identity. Will that go against them?
Right. Now, there is case law position on a situation where somebody is now disclosing a fact which undermines the previous fact held by the person himself or herself and a third party, in other words, the Secretary of State. There's case law position that if that happens, that may be held against you and adverse inference will be made of that. But let's go to the parameters within the new rule. The rule says that you may not be granted, and the word is may. That's the operative word. And so, much as if you are found to have entered the UK illegally, you will not be granted. In some circumstances, the Secretary of State is required to make a discretion and grant, if it is possible, that you may be granted. So much as you may not be granted, we may stretch the argument and becomes academic debate, actually, because we are looking at whether the person entered the UK illegally or not. When you were entering the UK, yes, granted, you came as A, but you know yourself to be B. If you entered as A, and that is what we know you by, did A enter UK legally?
Yes.
If A entered UK legally and A has now become B, then it's a matter of whether A's supposed deception is illegality in terms of entering the UK. And I do not see that as illegality in terms of entering the UK. It will be illegality on the point of suitability.
Okay.
It becomes an argument for the court to infer and determine whether the person should be considered to be an illegal entrant or should be considered as legal entrant with intent to deceive to enter.
Okay. So it becomes a different argument from what the
Exactly.
rule and the new regulations and guidance is saying.
Exactly.
Okay.
So it depends.
Well, folks, I think I will now ask you to give me an answer to my sin. Ajo and the partner Kabute had a baby that didn't survive after 23 weeks, or up to 23 weeks, the baby didn't survive. Kabute wanted to take paid leave from work to support her at home while they grieved. What will be his situation? Take a short break and we'll be back. Yes, so can Kabute take paid leave to support his partner, Joe? The three options: yes, he is entitled to 2 weeks of paid leave as a partner of Joe. No, because the pregnancy was less than 24 weeks. And three, yes, because the law provides for paternity leave. Remember, the miscarriage happened in week 23. Now let's go to the nugget. And the nugget says that the UK government has confirmed that parents who experience a miscarriage before 24 weeks of pregnancy will now be entitled to statutory bereavement leave of 2 weeks. Under the existing law, statutory bereavement leave applies only in cases of stillbirth, which is deemed to occur after 24 weeks of pregnancy or death of a child. So go back to the question. Let me say and ask you again. Will Kabute be given paid leave to support Ajo? Yes, he's entitled to 2 weeks of paid leave as a partner of Ajo. No, because the pregnancy was less than 24 weeks. And three, yes, because the law provides for paternity leave. Becky says it's number three, yes, because the law provides for paternity leave. Who else is coming up with something else? Komnabwedi says yes, he's entitled to 2 weeks of paid leave as a partner of Ajo. Joa Santua says it's number one. The next one here, let's see. Nanama says number two, no, because the pregnancy was less than 24 weeks. Let's see who else. Timothy Apia. Timo says is number three, yes, because the law provides for paternity leave. Nana Safo, number three, that says that, yes, because the law provides for paternity leave. Sami Mensa says is number two, because the pregnancy was less than 24. Vivian thinks so as well. Enoch Capone says number two, no, because the pregnancy was less than 24 weeks. Dinah Sechi says it's number one. Who else is coming up with something? Let's see. Maggie Ofosia says number one. Thank you for that. Theresa Tess says number three. Yes, because the law provides for paternity leave. Citizen Kojo thinks it's number two. No, because the pregnancy was less than 24 weeks old. Rebecca Mwakon, I think we've said that. Thank you very much for that. Nanaya says number one. Yes, he's entitled to 2 weeks of paid leave as a partner of Ajo. Who else? I think that's about all. Let me go to Lawyer Asma to find out what the answer would be. Ajo had a miscarriage at 23 weeks of pregnancy. Her partner Kabute wanted to take paid leave from work to support her at home while they grieve the loss of their daughter. Can Kabute take paid leave to support his partner, Ajo? Well,
So, Brakoko, if we go back to the nugget, the second part of the nugget, that is where the new measure
Mhm.
ensures that both mothers and partners can take up to 2 weeks bereavement leave following this, regardless of this and that. And so here it says up to 2 weeks bereavement leave. If we go to
regardless of
the
the
top,
stage of the pregnancy.
exactly, if we go to the top, that's the previous or the default position. Under the existing law, bereavement leave applies only in such cases which is deemed to occur after 24 weeks of and da da da. All right. So the question is whether Kabute is going to be Kabute's application to the employer for leave will be decided under the new law or the old law. Now, again, we are talking about paid leave.
Mhm.
The rules say that you can take bereavement leave. This is not maternity or paternity leave. It's bereavement leave. Do you get paid for bereavement leave or not? The rules are silent on whether you get paid for bereavement leave. So whilst you can have 2 weeks off to grieve that loss, as to whether you're going to be paid or not, we know that it's not about payment, but it can be taken compassionate or bereavement leave to do that. And so our brother here is seeking paid leave. Our brother is not just seeking leave, but paid leave.
Mhm.
will he get money whilst on leave?
No.
You see, so and therefore, even though when you look at it on the surface, you may think that, oh yeah, but this and that. If you stretch it carefully, you conclude that it will be no, because we have some statutory limitations regarding that. And so the new one says that you'll be given compassionate leave for 2 weeks, and but not maternity leave. You'll be given compassionate leave, but before you'll be given up to 24. So we'll conclude that the answer is no, because we are not looking at paid leave. We are looking at opportunity to grieve, but not with pay.
Oh, okay. So you could be giving compassionate leave, but not paid leave. So Kabute will not uh, be paid for the 2 weeks. You could be allowed to stay and support the wife, but you will not be paid for it because that is not what the new law even says. Well, thank you very much. And I think we will go back to our tradition and ask Lawyer Smart to briefly tell us what we discussed this afternoon, Lawyer.
Thank you very much, viewers and listeners. So today we looked at 3 things you may do or can do if you are refused a visa to the UK. We said that 2 actions will be given to you by the caseworker. Either you are told to go for administrative review, or you are told to go for appeal. You cannot mix the two. So go for the one that you are told to explore. The third one is usually not given, and that is judicial review. And it is available where you don't have administrative review right or appeal right. So judicial review is the third for those who are left unattended with any support. What we are saying here is that whether it is admin review or appeal or judicial review, it is something that is available and you have to pursue it up to the point where you know that you cannot really explore any remedy. However, in doing so, make sure that you assess the reasons for refusal to be sure that the caseworker is wrong. If the caseworker is right, then your admin review or appeal or judicial review may fail. But if the caseworker is deemed to have been harsh or unreasonable with the decision, then you may likely to succeed at admin review or succeed at judicial review. Court procedures are strictly evidence-based to assess whether the claim by the caseworker to refuse your application that you don't qualify is made out or not. If the claim is made out by the Home Office, then your appeal will be dismissed. If you are able to rebut the claim that you do not meet the rules, then your appeal is likely to succeed. There are instances where you may not meet, but the court may be sympathetic and conclude that if you are not granted anything, it may be unreasonable or harsh, considering your circumstance or your family life. And so the court also has powers under Procedure 4 of the Tribunal Procedure Rules 2014 to make certain decisions in your favor, even if you do not meet all the rules. All these are possible once you have pursued a particular course of action. Therefore, what we leave you with is that when you are refused a visa to the UK, seek advice from a lawyer. The lawyer will work with you to assess your chances of success in pursuing any of the 3 courses of action, and you'll be able to pursue your claim or remedy to ensure that you obtain what you want. Bear in mind, time, money, and patience are the things that are required to go through the process if you decide to pursue any of them. In all this, don't give up. Pursue one of the 3 actions depend on which one you are given to you, and fight and obtain what you need. Thank you.
Don't give up. One of the actions would help you. And overall, speak to BWF solicitors and they'll help you out. It's been a very interesting discussion this afternoon, and we've learned a lot. So I would want to appeal to you. I would want to plead with you. Come and let's do it again, same time next week on the same platform, BWTV, at BWF Solicitors Facebook, BWF Solicitors YouTube, BWTV Facebook, BWTV YouTube. My name is Oriku Frimpo. I want to say thank you on behalf of my production crew, Shilankra Padmodudu, Professor Ade, and the family of BWF Solicitors. We have it again, same time next week. Do make a date. Be good.